The next matter to come before us this morning is in re FB, GG, TG, JG, and ZG. Council, the applicant has waived oral argument in this case. You have 15 minutes to present argument this morning. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honors. May it please the Court, my name is Denise Ferguson. I'm here to represent Stephen Gerhardt in the matter of his children. I'd like to begin with my assignment of error that deals with the unauthorized practice of law. It is standard practice in the juvenile court that when a complaint is filed, it is written, the caseworker then signs off on it, a deputy clerk notarizes it, it is then filed. The first time an attorney becomes involved is at the shelter care hearing itself. Until then, the caseworker is acting on behalf of the agency, not on behalf of themselves. The statute states that any person with knowledge may file. And the prosecution and CSBs take that to mean that any person may file on behalf of another. They seem to add words in there that aren't there. And that changes the meaning of what the statute actually says. The statute is enabling any common citizen to come in and file a complaint alleging dependency, neglect, and abuse on behalf of themselves, or to hire an attorney to have that attorney file on their behalf. It does not allow for a CSB caseworker to file a complaint requesting that custody, emergency temporary custody, or anything else be granted to an agency. It's troubling to me that this goes on because in many other counties in which I practice, and even in this county, when it comes to an affidavit that is required, say for contempt of court or a motion to show cause, what attorneys do constantly is we write a motion, we refer to the affidavit and incorporate it into the motion by reference, and then attach it. That gets the requirements of an affidavit included in a motion, which is then filed by an attorney on behalf of somebody. The statutes in this state require that CSB be represented by the prosecuting attorney. I've quoted that law that states that the person that is to represent CSB in all court proceedings is the prosecuting attorney, assistant prosecuting attorney. And those are the only ones that are allowed to represent CSB. Filing a complaint is a form of representation. This court has found it in several cases, which I have quoted. And the Ohio Supreme Court has also found in Lorain County Bar Association versus Kokak that preparing and filing legal papers on another person's behalf constitutes the unauthorized practice of law. Therefore, CSB caseworkers who sign these complaints without an attorney, who are requesting something on behalf of the agency, are engaging in the unauthorized practice of law. Ms. Walker, in this case, testified that she did not want custody of these kids, but yet she filed for emergency temporary custody. She also stated that she was not an attorney, but she engaged in the rendering of legal services for another by any person not admitted to practice in Ohio. The Supreme Court has stated that if a case is filed by someone who's not an attorney and who is engaged in the unauthorized practice of law, that filing is void. I know there is a case out of the 9th, and I'm looking for it right now just to make sure I get the proper name. Marvin Raspberry versus Tony Taylor. That was one of your cases. 2013, Ohio 2175. Taylor was being evicted from a home owned by Marvin Raspberry and Spencer Gibson. Raspberry filed the eviction complaint on behalf of himself and the other co-owner. He wasn't an attorney. Gibson appeared at the hearings while Raspberry did not, so they both engaged in representing the other. This court remanded the case back to have the trial court address the ramifications of Mr. Gibson's failure to sign the complaint and determine whether Raspberry was an attorney, because the record was silent in that case. In this case, the record isn't silent. I believe that this case should be remanded back, found to be void by this court, and dismissed at the trial level due to the unauthorized practice of law. Now, the other issue that I have raised is the reasonable efforts. While we may have stipulated to reasonable efforts at the trial level, that does not mean that the findings themselves are adequate or correct. The findings are supposed to include two different prongs. They're supposed to state what reasonable efforts were engaged in and whether or not, why those reasonable efforts did not allow the children to be returned home or prevent the removal. Well, the court did state what was done by the agency. It doesn't state the second prong of that, which is how or why not the court, why the reasonable efforts did not do anything to prevent the removal or return the children. The third issue, and I'm sorry to be moving through this kind of quickly, is we may not even have a final appealable order in this case. It was remanded back once for lack of a final appealable order. In this case, when the judge rewrote the decision from which we appealed, she did not put in a dispositional finding of the fact that the children should be in the temporary custody of CSB. She referred back to other orders that had been administered in this case by saying anything not in contradiction is still upheld. So we may not even have a final appealable order. If we do, however, I believe this case should be reversed and remanded on the filing of a complaint by a non-attorney. And I did raise that issue 7 days in the proper time period back then, which has been about 2 years now. Are there any questions? Okay.
Thank you, counsel, for your presentation this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you.